Our objective is just to objectively analyze her firsthand account of this battle.
We're basically looking at the anatomy of the conflict itself, right? The friction between property rights, institutional power, and the harsh realities of trying to fight the system.
Yeah, because whether you rent a loft, own a condo, or, live in a suburban neighborhood governed by an HOA, the underlying mechanics are essentially the same.
Oh, 100%. And this all begins with, as we said, an incredibly mundane physical catalyst.
Just a leaky pipe. Right. According to Rosalind's document, the origin point was actually a water loss event back in 2021.
Okay.
Yeah, followed by a recurring active leak and a mold issue that resurfaced in July of 2024.
And water damage in shared wall architecture is notoriously complex, right? Because water doesn't respect legal property lines.
No, it really doesn't. It travels through common elements right into private airspaces.
Yeah, and Rosalind's script explicitly details how she traced this 2024 active leak back to the exact same main line and the prior repair history from 2021.
And she points directly to the community's own governing materials, which she claims acknowledge that the association holds responsibility for common plumbing lines.
Okay, let's unpack this. Because the traditional promise of an HOA is supposed to function as like an infrastructure insurance policy.
Right. You pay your dues so the shared elements get fixed.
Exactly. But Rosalind asserts she faced all these delays, blame shifting, and technical excuses. The phrase that practically leaps off the page of her account is being told the damages were, quote, under the deductible.
Yeah, that's a crucial point.
How does an insurance deductible suddenly absolve an organization of its responsibility to maintain a pipe? I mean, when does a structural failure become a systemic failure in accountability?
Well, that requires a look at the actual mechanics of HOA management. So boards hold a master insurance policy for the building, right?
Right.
And homeowners hold individual walls-in policies. So when a pipe breaks, management typically submits the claim to the master policy.
Makes sense.
But if the cost of the repair or the damage is less than the deductible, say the deductible is $10,000 and the repair is $5,000, the insurance company obviously won't pay out.
Right, they just close the claim.
Exactly. The claim is administratively closed. But here's the critical gap. Boards frequently use that insurance denial as a shield against their actual liability.
Wait. I have to challenge that. Just because their insurance won't cover it, that doesn't mean the pipe isn't broken.
No, of course not.
And it doesn't mean the pipe isn't their property to fix. That just sounds like a fundamental misunderstanding of what insurance even is.
Yeah.
Insurance is a funding mechanism, right? It's not a liability waiver.
And that is the exact friction point Rosalind highlights. From an administrative perspective, the board sees a closed insurance claim and considers the matter resolved. They just pack up their files.
Wow. But from the homeowner's perspective, the physical reality hasn't changed at all.
Exactly. The water is still dripping. The drywall is still rotting. A technical denial doesn't, magically dispatch a mitigation crew.
No, it definitely doesn't.
And Rosalind states in her document very clearly, she says, a technical denial is not the same thing as being made whole.
That's a powerful way to phrase it. So it's basically a systemic failure masquerading as an administrative technicality.
Yeah, absolutely.
And she gave notice, right?
Yeah.
She tried to comply with her processes. She spent months trying to get this resolved without ever wanting to set foot in a courtroom.
Right. She literally wrote, court was not the first choice. It was what was left.
Yeah, and taking an institution to court over a habitability issue, that is stepping over a major threshold.
It's huge. You are demanding accountability from an entity that has vastly more resources than you do.
Right.
But by September 2024, Rosalind felt she had exhausted literally every non-judicial avenue, and she filed suit.
Okay, here's where it gets really interesting. Because once she files that suit, the conflict just mutates.
Yeah, it doesn't just escalate. It fundamentally changes shape.
According to her records, the dispute abruptly expands, like light years beyond a leaking common pipe.
Mm-hmm.
Suddenly, she is facing intense scrutiny over her occupancy.
Which is wild.
Yeah. Then come accusations regarding her lease. Next, she's hit with enforcement rules regarding her dryer vent.
Dryer vents? Really?
Yes, dryer vents. There are sudden hearings. There are legal counterclaims. She calls this a campaign. And she uses this amazing phrase. She calls it bullying that puts on a business suit.
Bullying in a business suit. Man, that perfectly captures the mechanics of institutional pressure.
It really does.
Because when we picture bullying, we usually envision, interpersonal aggression, someone yelling, making threats, physical intimidation.
Right, the playground bully.
Exactly. But institutions don't need to yell. They use process, They
Okay.
apply pressure through like an avalanche of formal notices.
Sudden audits of your compliance with obscure bylaws.
Yeah. And mandatory hearings scheduled right in the middle of your workday.
Okay, I see what you're saying, but let me play devil's advocate for just a second.
Yeah.
Is it possible that this is just, I don't know, standard administrative protocol?
How do you mean?
Like, if a resident is suddenly in the spotlight because of a lawsuit, maybe the management company is just doing a thorough review of her file and they're just noticing other infractions.
Well, I mean, theoretically, sure.
So how do we separate routine rule enforcement from a targeted retaliatory tactic designed to exhaust her? Because her document clearly frames it as retaliation.
Well, you look at the timing and the volume, right? When a resident reports a major structural failure that threatens their health like mold from a common pipe, and the response is a sudden flurry of notices about dryer vents and lease technicalities, it really signals a shift from maintenance to defense. It's actually a really well-documented strategy in asymmetrical conflicts. It's designed to dilute the homeowner's resources.
So it's about distraction and exhaustion.
Exactly. If you have, say, 10 hours a week to fight for your home, and suddenly you have to spend 8 of those hours proving your dryer vent is up to code and defending your occupancy status.
You have no energy left to fight about the water leak.
Precisely.
It's like she sat down to play chess to resolve the water issue, and her opponent just dumped 5 more boards onto the table, set all the timers, and said, "Your move on all of them right now."
That's a great analogy. It's an intentional overwhelming of her bandwidth.
And it forces a defensive posture.
Right. Totally. You are no longer solely the plaintiff seeking justice for a damaged home. You are suddenly a defendant trying to prove you even belong in the community at all.
Man. And administrative processes, while they're ostensibly designed to maintain community standards, they can just be so easily weaponized.
Because sending a formal violation notice is nearly costless for a management company.
Right, they just hit print.
Exactly. But defending against it, that requires immense time, documentation, and stress for the homeowner.
Which catapults us right into the most staggering disparity in this entire story.
Yeah.
Rosalind is facing this multi-front administrative war.
Yep.
The institution holds the management company, the board's authority, the collective finances of the community, which ironically includes her own dues, and a team of corporate lawyers.
Right. And Rosalind, on the other hand, describes a really desperate struggle to find stable legal representation.
Yeah, she reached out to newsrooms, investigative journalists. Silence. The phones didn't ring back, so she was left to litigate pro se.
And for those who don't know, litigating pro se, representing yourself in court without an attorney, is one of the most daunting tasks a citizen can undertake.
I can't even imagine.
You aren't just showing up to tell a judge your story, you know? The legal system doesn't operate on narrative. It operates on strict, highly formalized rules of civil procedure.
Let's make that tangible for the listener. What does a random Tuesday night look like for a corporate HOA lawyer versus a pro se homeowner?
Well, the corporate lawyer goes home, sleeps, and has a team of paralegals draft a motion to dismiss based on, like, a specific jurisdictional precedent.
Using specialized software and years of training.
Right. But the pro se homeowner, they work a full 8-hour day at their actual job, come home to a house that might still smell of mold, and they spend from 8 p.m. to 3 a.m. on Google Scholar.
Just trying to decipher the difference between a motion for summary judgment and a motion to dismiss.
Exactly. And just praying they don't format the margins wrong and get their entire filing rejected by the clerk.
And Rosalind left a massive public footprint of this struggle. She lists cases like 24 GC 06635, 25 J 02932, and 25 CV 06808.
Yeah, those are tangible public records of a citizen just trying to navigate this labyrinth.
But in her document, she makes a really profound observation about this whole process. She states, quote, "A procedural loss is not the same as the damage never happening."
That distinction right there is the philosophical core of her experience with the courts.
Explain that a bit more.
Well, the justice system is essentially a machine designed to process rules. It is not necessarily designed to independently discover objective truth.
Wow, that's bleak.
It is. If a pro se litigant misses a filing deadline or, fails to state a claim using the precise legal terminology required by statute, the court will dismiss the case.
So what does this all mean? I mean, it's like being forced into a high-stakes professional sports match without knowing where the out-of-bounds lines are. And the referees are penalizing you for rule infractions you didn't even know existed. When an institution wins because of a procedural error, do they view that as a legitimate victory?
Legally, yes. A dismissal is a win for the institution. It stops the bleeding of their resources and it closes the file.
But philosophically.
Philosophically, and from Rosalind's perspective, it's a profound failure of justice. A technical dismissal effectively erases the factual reality of the homeowner's lived experience in the eyes of the court.
Because the water still flowed.
Yes, the mold is still there. The damage is physical and real.
But legally, if you lose on a procedural misstep, the system acts as if the event never occurred.
Exactly. The truth of the matter is swallowed entirely by the machinery of the process.
The machinery just grinds the reality down to dust. And the institution gets to issue a statement saying, oh, the court found no merit in the claims, when in reality the court just found a missed comma or an improper filing window.
Yeah. And this highlights such a dangerous vulnerability for anyone who lacks institutional backing.
Because it creates an environment where the party with the most endurance.
Right.
And the deepest pockets, they almost always prevail.
Regardless of the underlying facts, institutions can afford to play the long game. They can file endless procedural motions to delay, to exhaust, and to drain the pro se litigant until they just simply give up.
And that exhaustion isn't just physical. I mean, beyond the legal filings, beyond the dryer vent notices and the late nights reading civil codes, there's a human being actually living inside this pressure cooker.
Yeah, we have to remember that.
The legal battle is only half the story. The other half is the psychological and emotional devastation.
And Rosalind discusses the emotional reality of her situation with remarkable candor in her script. The timeline of this dispute, it didn't happen in a vacuum.
No, it really didn't.
She was fighting this multi-front war against her HOA while actively grieving the death of her mother.
Just pause and think about the weight of that. You are dealing with profound personal loss. A time when your home is supposed to be your ultimate sanctuary, right?
The place you go to heal.
Exactly. And instead, your home is the source of a seemingly hostile conflict. She talks deeply about the profound isolation of it all.
Yeah, feeling marked as, quote, the problem, simply because she was the one holding up a hand and saying, hey, there's a problem here.
That social isolation is a very common, very dark consequence of challenging an institution within a closed community, isn't it?
It really is. In a condo building, you share walls, hallways, and parking lots with your neighbors. When you become the target of the HOA's administrative machinery, your neighbors notice.
Of course they do.
They might agree with you privately. They might even have the exact same water issues. But they see the avalanche of notices and the legal battles you are facing, and a chilling effect takes hold.
Because they don't want to be the next one in the crosshairs.
Exactly. They stay quiet out of self-preservation.
But for the person fighting, it means just walking to your mailbox feels like running a gauntlet. You are entirely cut off.
Yeah.
And Rosalind's ultimate advice to other homeowners facing this kind of institutional Goliath is really telling. She just says, document everything.
Save the emails, print the notices, take the photos, build the timelines.
Because it is the only defense mechanism available, right? When an institution uses its authority to dictate what the official truth is, a meticulous paper trail is the only way to prove your reality.
Yeah, but consider the psychological toll of that.
Oh, it's a complete double-edged sword. Yes, the documentation saves your case.
Yeah.
But it turns your daily life into a full-time archiving job.
You are no longer just living in your home. You are surveilling your own life.
Does this kind of hyper-documentation morph into, almost a trauma response?
I think trauma response is a highly accurate way to frame it, actually.
Because you're desperately holding on to pieces of paper and time-stamped photos. Because it's the only proof you have against a system telling you that what you're experiencing isn't real.
Exactly. When an institution gaslights you, when they tell you a structural failure is just a minor deductible issue, or when they try to reduce your painful lived experience into a sterile, easily dismissed administrative dispute,
Right.
an obsessive record becomes your anchor. It proves you aren't imagining things.
The record shows. That phrase basically becomes her shield against the gaslighting.
It does. And it requires immense, almost unfathomable resilience to keep pushing that rock up the hill when the entire system is structurally designed to make you quit.
Yeah.
Rosalind's decision to launch Green Couch Conversations, to take her documented script to the public, it stems from a really powerful realization. She states, if nobody will speak for me, I will speak for me.
Because, as she puts it in one of the most striking lines of her document, silence protects the powerful.
That is the crux of the institutional advantage right there.
Right. Institutions thrive in the shadows of complex bureaucracy.
They rely on the fact that civil procedure is boring to the general public, that reading HOA bylaws puts people to sleep.
and that most homeowners will simply surrender when faced with a 5-page legal threat.
Exactly. By making the dispute public, by explaining the actual mechanics of the bullying, she strips away that cover of silence.
Well, we've covered a massive amount of ground today. We traced the anatomy of a conflict that began with a simple, localized plumbing issue in Smyrna, Georgia, and we watched it unfold into a multi-layered legal and personal siege.
We examined how the mechanisms meant to protect a community. Insurance policies, bylaws, administrative processes, how they can be inverted.
Yeah. From the homeowner's perspective, seeking basic accountability triggered a cascade of counter-pressure, selective enforcement, and procedural traps that made the pursuit of justice feel nearly impossible.
Particularly when navigating the legal labyrinth pro se.
And that reality checks right back to you, the listener. It doesn't matter if you rent a basement apartment, if you own a high-rise condo, or if you live in a gated community with a seemingly benevolent HOA.
The systems governing your immediate living space require intense, proactive scrutiny.
Rosalind Grigger's heavily documented story is a glaring warning. You have to understand the rules of engagement, the limits of your master insurance policies, and the true nature of your community's bylaws before the pipe bursts.
Because the moment the water starts leaking, the glossy brochure version of community living vanishes.
Yep.
And the rigid contractual reality of institutional self-preservation takes over.
Which leaves us with a final vital thought for you to carry forward. We live in an era where local community governance boards, like HOAs, hold unprecedented power over our daily lives.
They can dictate what we do with their property, they can levy massive financial assessments, and they can force us into grueling legal battles using our own collected dues.
Yet, are these microgovernments operating with anything resembling the checks, balances, and constitutional oversight that we demand of our actual city or state governments?
That's the real question.
Or, in our rush to secure a piece of the American dream, have we accidentally signed away our fundamental rights in the fine print of a community charter?
It's definitely something to think about.
Think back to that idea of your home as a fortress. You might hold the key to the deadbolt, but you have to ask yourself, who else is holding the master key to the walls?
Thanks for having me. I'm really looking forward to getting into this.
Yeah, so today we are looking at a fascinating primary source. It's a master planning document created by a homeowner named Rosalind Grigger.
Right, and she put this really comprehensive script and record together for her own public storytelling project.
Yeah, a series she calls Green Couch Conversations. And the setting for this whole thing is the countryside at